Alrighty, we are back with John Byerly, the Deputy Assistant Secretary of State for Transportation Affairs, as he ends his illustrious career as a public servant. What's next for you?
I haven't decided. I'm going to take 2 months off, is at least my current plan. Get our kitchen countertops replaced, work on our roof, do a little painting, help my elder son, who's a senior in high school, visit a couple colleges as necessary, decide where he's going to go. And during that period also think about what I'll do next. So no decisions whatsoever, Ken.
You're going to remain active?
I'd hope to, but we'll see if anybody is interested in my remaining active.
And someone told me at the break that you didn't answer one of my very serious questions, which was the first one. How's a kid from North Carolina end up where you ended up?
I thought I had answered it. Pure luck.
Pure luck.
But I was a hard worker as a kid. I think I've gotten lazier in my old age. But I got to go to a great university, great law school, work for the U.S. government, which is an incredible honor. And
would you recommend that to law students coming out of this illustrious university or others to go do a government stint?
Absolutely.
Or an entire career?
Absolutely. I've had a great career. I've enjoyed my life in the law, in my professional life, and the motivation of being able to wake up and think I'm doing something that makes a difference. You can do that in the private sector, but I think it's maybe a little bit easier in the public sector to think about your job that way. I've always thought about mine that way. The ability to bring people together, and that includes folks in airlines, airports, unions, to build some bridges across international borders through aviation. That's really rewarding.
But did you ever envision in your wildest dreams that you would be so groundbreaking in international aviation as opposed to making a difference in Namibia or in Mozambique, the career service officer route?
I was also lucky that when I did African affairs, it was a period of opportunity. And I arrived after, for example, Chet Crocker, the Assistant Secretary, had spent some 6+ years working to construct the possibility for a deal to get the Cubans out of Angola and the South Africans out of Namibia. And when I arrived, replaced a wonderful assistant legal advisor who had been working with him. The moment was right. It was the end of President Reagan's administration, and everything came together. So it was the luck of timing.
So if someone else had filled that attorney advisor role in aviation or the policy role,
right,
we wouldn't be sitting here today. You wouldn't have been such a big part of the U.S. Open Skies Agreement with the European Union.
I think if that opening had not been available in 1985 as an attorney advisor in aviation, I'd have done something else. Who knows, Latin American affairs or African affairs or political military affairs in the legal advisor's office, and probably wouldn't then have had an opportunity later to come back to aviation.
You speak 3 other languages.
I speak German well. I manage French, and in the 2 years I spent in Italy as general counsel of the Sinai Peacekeeping Force, it has its headquarters in Rome, great place.
Oh, by the way, I was general counsel of the Sinai Peacekeeping Force. I forgot to mention that.
I learned a little bit of Italian, which is a fun language and a great place to live. But really,
yeah, how did you get a stint with the multinational forces and the Sinai Peacekeeping, but happened to do it from Rome? That's a nice gig.
So when Jimmy Carter did the Camp David Accords that led to the withdrawal of Israel from the Sinai, but under an arrangement that demilitarized the Sinai, a peacekeeping force was necessary to monitor the provisions, how many tanks, what sort of troop levels and types of personnel could be in various zones in the Sinai Peninsula. Because of the opposition to what had been done in those agreements, the United Nations didn't take on that peacekeeping mission. So the United States and some others went around the world and put together a freestanding peacekeeping force, still today, not under the United Nations, called the Multinational Force and Observers. They set that operation up, and they couldn't put it in Israel, they couldn't put it in Egypt. They looked around. I know Cyprus was a possibility, but the Italian government offered Rome as a headquarters, and a brilliant decision was made.
And
that
did
would
you
be a
put your
nice
hand
place
up
to
at that
be.
point?
No, I joined
I'm
the
happy to bring
organization.
peace, especially in Rome.
I joined the organization many years after it had been established. It was a very successful organization then and today.
Let me ask you about some people in aviation.
Sure.
And give me some reactions. Bob Crandall.
Brilliant, one of the great innovators in aviation, extraordinary figure, articulate, says his piece.
Did you ever get one of his letters with exclamation points and an underline, maybe 2 sentences? Why the hell are you doing this?
No, but I've heard about those letters. I've heard about the notes he'd passed to his staff from first class back when he was flying, and would keep them very, very busy. Extraordinary man.
Glenn Tilton,
Brilliant.
chairman of United Airlines here in Chicago.
So Glenn joins United Airlines with no background in aviation, except, I guess, as someone who'd flown on airplanes. People were skeptical at the time, and what we see today is the dean of the aviation CEO community. He's brought his airline through an extended bankruptcy into success. He's consummated now a merger with Mr. Smisek at Continental. I think looking at results, you've got to say Glenn Tilton's done an extraordinary job in making United a good carrier, an even bigger one, and one that is here to stay with enormous power and force.
It was interesting when we were fighting the battles over Virgin America and the opposition of all the labor unions and airlines. Notably absent was United Airlines. They weren't going to challenge the citizenship of a carrier that was alleged that Sir Richard was too involved in. Is that indicative of United's approach to liberalization, free trade?
Let me answer that this way. Glenn, Tilton, United have been among the leaders in the U.S. airline community in saying we need to take a close look at the issue of ownership and control, at looking beyond sort of a traditional model to a more global system. Maybe that relates to United's extraordinary position in international markets, but I think it also is tied to Glenn's own vision. It comes from the oil industry. It's a global business. You have foreign oil companies here, we're overseas. It is inherently global business. Somehow, I think he believes, I certainly believe, airlines are an inherently global business. It's the nature of the work, and yet where you can have mergers and combinations and presences in the oil industry, which is certainly a national security related industry for every country, we don't have that in aviation. So Glenn, I think maybe coming from that perspective, I haven't taken his interview on this point, but I think coming from that perspective probably says this is unnatural.
This is crazy,
in aviation.
right. Richard Anderson, CEO of Delta, former Northwest
Again, has
executive.
done a fantastic job with Delta. Lots of people were skeptical of whether Delta could surmount the sorts of problems that had created major headaches in other airline mergers. My sense is the Northwest inclusion into merger of Delta and Northwest has gone far beyond expectations in merging two cultures, two very different airlines, one way up in the north, one in the deep south, and they've got a very effective airline, and their numbers show it.
Someone near and dear to me, Sir Richard Branson.
Brilliant. And we need someone like Richard Branson to challenge the big players on the scene. He's done it with a product people like. I've had only one chance with the Fly America Act in my life to fly a one-segment piece on Virgin. Great product. You like flying them. He's brought sex appeal back to aviation. He's a consummate salesman. He gets all this advertising for free, dresses himself up like a bride, all in white, for Virgin Brides, which didn't succeed, but he got a lot of free publicity.
No, but he actually,
Brilliant guy.
he dressed himself up as a minister and married a couple on our launch from San Francisco to Las Vegas. After that, he rappelled down one of the casinos and hit the window and dropped all the free tickets. But it was
What a
interesting.
life, a bigger-than-life figure.
Daniel Calleja.
One of the consummate negotiators, dealers.
Who is he?
Okay. Daniel Calleja is the Director of Air Transport in the European Commission, today called the Director General for DG Move, Transport and Movement. He was my counterpart in both sets, the first set and the second set of US-EU negotiations. Before that, he'd been Loyola de Palacios, the Vice President of the Commission's Chief of Staff. Spaniard, lawyer by training, absolutely brilliant guy, unbelievably nice fella.
Charming.
charming in every respect, but his principal talent was the ability to herd the cats of the European Union, to bring consensus among 27 member states, among different pieces of the European Commission, to bring them into line into one position, and he could present at the negotiating table over successive round after round after round of negotiations. His job was 10 times as tough as mine was, and I thought I had a pretty tough job, so he deserves a medal.
Jeff Shane.
Again, one of the great thinkers at the forefront of
He had
US
your
aviation
job.
policy. I met Jeff for the first time in my life in 1985. I came back from Berlin. He was my client. He was the Deputy Assistant Secretary of a job I have today. I was his lawyer. A mentor, a thinker, a person who can step back from the trees and see the whole forest. A brilliant speaker, able to articulate tough ideas in understandable terms, and in many ways, the originator of the specific open skies concept and the person who drove it ahead, got our first deal with the Netherlands.
Best Secretary of State that you've worked with?
Oh, I wouldn't answer that. I've worked with very different personalities. They've all
A true
been
diplomat.
They've all been extraordinary leaders, and no, I pass.
We won't do the Charlie Brown wah. Okay. Secretary of Transportation. Do you have a favorite?
I don't have a favorite. I've worked with a number of under the direction or the guidance of various secretaries of transportation. You know, if you work with someone like Secretary Mineta, who loved transportation his entire life in the Congress, who crossed party lines to say there's nothing Republican or Democrat about building a bridge, building an airport, encounters when he comes in as Secretary of Transportation at DOT the challenge of 9/11, sees his own agency lose pieces, including pieces of which he was, and DOT has always been so proud, the Coast Guard, the security element of the FAA, and to manage that process, again, one of the most likable human figures. You see Secretary Mineta, he always knows your name, all the way down the delegation list, incredibly personable, human, and made a real difference. Not that I'm saying he's the best Secretary of Transportation,
not. We wouldn't,
but he's an
put you on
example
the
of
spot
many,
like that.
many good people.
Chairman Jim Oberstar. He's
Again,
been at odds with your liberalization march, and it's fair to say, is it not, the principal obstacle to breaking down the barriers to free trade and foreign ownership restrictions?
I have the highest respect for Chairman Oberstar, and I've worked with him and his staff for all the years I've been involved in aviation in a policy position, so since 1995. He has an extraordinary breadth of knowledge, not only of aviation, but of all transport modes, including bicycling. And you know, that's a great thing to push. The maritime industry, our road industry, surface transportation. He's passionate about the subject. He cares about aviation. He's articulated strong views that have not been consistent with, certainly in this administration and the past administration. The move towards consolidation is something he worries about. Those worries are not illegitimate. What I've found on a personal basis is he's always open. He's someone you can talk to. Again, someone who remembers your name, treats you like a human being, not some bureaucratic fodder. Tough hearing. I had a hearing I was with Jeff Shane at the table when Chairman Oberstar held a hearing on the notice of proposed rulemaking. It wasn't one of the easier days in my life, but he was
Like you still have the marks where the jockey was hitting you?
Jeff took the larger arrows and slings and spears, but fair and open. And I know that when we had controversy over closing the negotiations with Japan last December 2009, Chairman Oberstar wanted a briefing right in the middle of the negotiations because there was controversy. Should we go ahead or not? We went in. He had, I think, almost a dozen members, 10 members of the House Transportation Infrastructure Committee there on both sides of the issue. He asked good questions, and at the end he gave us a vote of confidence. He didn't say he fully agreed or that he disagreed with what we were doing, but he said, you're professionals, you know your business, you have our trust, you're the United States, we're all together in this, was the message. I really appreciated it.
But when the administration was proposing to relax foreign ownership and redefine the actual control test of citizenship, I don't think the message was, you have my trust, God bless you, go forth, do good.
Not at all. And so this is one of the sadder, unhappier experiences and chapters in the modern aviation story. Just to roll back a little bit the story, we were in the negotiations with the European Union. We had sought what we called an early harvest agreement.
What year are we talking?
2004. Sought an early harvest agreement. Mandate was granted.
What do you mean by that, early harvest?
So a mandate was given to the European Commission to negotiate in 2003. We started the negotiations that fall. We continued through the spring of 2004. We were very close to reaching an agreement, but the Europeans said no to the package that we'd put together. It had only a minor element on ownership and control, which was we would look to increase from 25 to 49%. Our
voting equity.
Voting equity. Not, frankly, I think, a very significant step. The European member states rejected that precisely, well, in part because that really wasn't a meaningful step. So we had to go back to negotiations. They wanted ownership and control opportunities open up to control U.S. carriers, not 49%, but the potential for 100.
And they said we will eliminate our restrictions on foreign ownership entirely.
In fact, their legislation, the legislation under which Daniel Kaleha was negotiating, had his mandate, allowed the waiver of European restrictions on ownership and control if there was reciprocity with the partner country.
Do you recognize as a negotiator that this is an historic moment that you could seize to really transform the aviation industry and probably consolidate it and make it a lot healthier?
Absolutely. Once we got through the initial reaction to the European Court of Justice decisions in November 2002, the reaction from Commissioner de Palacio that the existing
By the way,
agreements...
Chairman Oberstar has arranged to have a siren come in at this moment so that we can... And this will be John being pulled away from this negotiation.
In handcuffs.
In handcuffs.
Shackles.
Shackles. Go ahead.
In any event, we had tried to have what we called an early harvest agreement, which would have been open skies throughout the European Union. We would have recognized the European...
Meaning from
skies.
any point to any point
Any
with
point.
as many frequencies.
And including then the benefit for the European Union, including an open Heathrow. But the benefit for the European side, something they would gain, was we would have accepted the European carrier concept. So not only BMI from London Heathrow to the United States, but Lufthansa, Air France, Iberia, any European carrier from any point in Europe, a major expansion of traffic rights. In any event, that package was rejected in the summer of 2004 by the European side. We pondered for a year. Went back to the table.
For a year?
Yeah, until 2005. In fact, over a year. Went back to the table in 2005. Negotiated, again, hard, and came up with the concept of doing, we knew that 49% wouldn't do it. The decision was taken by DOT under Secretary Mineta at the time, and the White House had been consulted that the time was not ripe to seek statutory change on ownership and control. And it was tied to the big picture as I understood it. I was not personally engaged in those discussions. That there were too many other legislative initiatives. The chances of success were limited.
Limited?
Limited to low.
Bit of an understatement.
And that the support from industry, frankly, wasn't there.
Isn't that part odd?
I think airlines, including airlines that were supportive, like United, like Federal Express, they've got 101 other items on their legislative agenda, and they have to prioritize what's most important to the company. No one was putting changing the ownership and control laws as number one.
So let's stop there in the chronology. Is it fair to criticize the U.S. airline industry for not coalescing around a position of breaking down foreign ownership restrictions, insisting on legislative change so that they can consolidate and acquire other carriers and also increase market opportunities?
I wouldn't criticize them. I think they made rational decisions based on their own interests and their obligations not to make international aviation policy. Their obligations to their stockholders, to their employees, to making their airlines a successful venture. And this simply, in the near and medium term, probably wouldn't have made that difference. So
But wouldn't that help?
to
That
criticize.
would
It
have
would have
helped you,
helped,
though, right? I mean,
Absolutely.
if you had all the airlines saying we support a statutory change in the foreign citizenship requirements, or we all support a revised interpretation of the actual control test, this would have made your life easier.
It would have made it easier with the NPRM, which proposed an interpretation, an express interpretation.
Tell us about that.
So DOT, having decided not to pursue statutory change, looked at what could be done within the framework of existing law. The law had been changed a couple years earlier in connection with a dispute among cargo carriers involving DHL, FedEx, UPS, to insert the words actual control into the statute. So only
Which had never been in the statute.
had not been in the statute.
45 plus years of just, it was a DOT-made,
CAB, DOT
CAB.
made interpretation.
Detweiler case, as I
Right.
recall.
You're the good lawyer with the memory for the case names, but
We're in
I
law
do
school,
remember
we got to
that.
know the sites, come on.
So the idea was, we're not going to pursue legislative change, but there is discretion of an administering agency to decide how it will apply the existing statutory laws. Under the so-called Chevron doctrine, discretion is given to the administering agency's decisions.
Now we're really getting excited with administrative law as well.
DOT examined the statute and concluded. Karan Bhatia was there as the assistant secretary, Don Horn as the assistant legal advisor or assistant general counsel for international law.
Keeper of the foreign ownership flame.
Right, but also knew what really an insightful lawyer, an incredible hard worker, good friend.
Yep.
Felt that DOT had it within its discretion under the Administrative Procedure Act, under the Chevron doctrine, to interpret the law in a way that made sense, but would also be meaningful to the European side. I mean, it's not, one can't argue that the European interest in seeing movement by the United States played no role. It played an important role in motivating the examination. So they proposed an interpretation in a very public way, a notice of proposed rulemaking, came out with an interpretation that would have said actual control is a test that we will apply by looking at safety, security, basic corporate governance, and the fulfillment of requirements for the national security of the United States, the CRAF program. But commercial
The Civil
operations,
Reserve Air Fleet.
yeah, exactly. But if we're not going to focus on branding the product or corporate deals or code sharing, we're going to focus on this core identity of the airline and things that are really important.
So
to
as long as
American
a
policy.
U.S. carrier controlled the ability to force carriers to participate in the Civil Reserve Air Fleet program, other commercial aspects could be controlled by a non-U.S. citizen.
Could be controlled by a U.S. citizen, provided also that the airline as a whole remained under the control of U.S. citizens, basic corporate governance. This interpretation was put out. It was then supported by some, but it was
Let me
also
challenge you there.
criticized.
This interpretation was put out for comment. I busted the chops of my friend Jeff Shane that was a colossal error. You never should have asked for comment. You should have just done it. Agree or disagree?
It's really hard to turn back the clock on such smart lawyers as you or Jeff Shane and say which would have worked.
I had to get that in somehow.
Since
It's the
Jeff's
only way I could
approach,
think
since
of.
the DOT approach didn't work, I think maybe another approach could have been tried. But I think it's important to look at a couple things. We had some stakeholders who'd not been brought into the picture in advance. Labor had an incredibly negative reaction. Continental Airlines at the time was not ready to move forward with open skies with the European Union because of concerns about access to Heathrow. And Congress was briefed only as the NPRM was rolled out. Not a good
But
practice.
why weren't you saying, as the great lawyer that you are too, interpret the law, it's a fait accompli, labor wants to challenge us, we'll go to court, we have Chevron deference, on our side. You've already said that. We win 90% of these cases anyway. It's the law. We've interpreted it. It's an ambiguous statute. We're saying actual control means so long as you're not controlling national security, it's okay.
I think, Ken, one reason that DOT wished to do and decided to do a formal rulemaking was to make evident to the European Union that this was not a case-by-case matter that could be changed randomly in the future, but it was an articulation of policy that would nudge in a significant way toward the European direction. And putting that in, ink on paper was a way of doing that, and that was a driving factor for doing it in that manner.
And is that also an indication that history would have been different had we had a transaction where DOT actually could have issued an opinion based on particular facts that liberalized foreign ownership, right? So
It's conceivable.
Northwest KLM was just that, right? We had Northwest KLM,
Yes.
Wings 1, Wings 2. Based on a transaction, we reinterpreted the actual control test to say you could go from 25% total equity to 49% total equity, and we'd ignore multi-billion in foreign debt.
Conceivably, if you'd had at that time, not later, the Virgin America case, in which you were so deeply involved and successfully so, an opinion could have come out that would have satisfied the Europeans. It's really hard to know. What
Hindsight.
mattered was it didn't work out. It then took us about a year to figure it wasn't going to work out, and in the fall of 1996, I believe, we had that meeting at the White House at the old executive office building.
Yeah, what happened there? Why did you go south to Tijuana on this? But why did you not just say, stick to our guns? We understand Chairman Oberstar's position. We understand organized labor's position, but this is the right thing to do. And I need this to negotiate a truly global open skies agreement with the European Union. Issue and finalize this rulemaking. We'll defend it in court.
The broad view was, of the legislative experts, that Congress would have passed legislation, if not immediately, soon thereafter, that would have reversed the decision. And that the chances of sustaining a veto, had the President decided to veto that legislation, were anything but certain. Therefore, it would have been a Pyrrhic victory, in all likelihood, to have gone ahead with the rulemaking, finalized the rule, and then seen Congress reverse it.
Were
And
you
you'd have paid a lot of
disappointed
other
with the
prices.
Bush administration? I mean, one of the faults of George W. Bush, people and historians and myself included, criticize them for not vetoing enough bills. He didn't exercise the power of the presidency in the veto pen, so that we have things like TSA today as a result on a bill that should have been vetoed. Were you disappointed in that outcome, that the
No.
administration?
By the time we reached that decision point, I was an ardent supporter of yank the rulemaking, stop it.
You were, okay.
It's not going to succeed. We need to get back to the negotiating table and find a substitute. And
But there weren't any.
Well, there were.
There were, okay.
So what we did was we found a package of smaller elements, not some big bang of movement on ownership and control, but a package of smaller elements that the Europeans in the end decided did the trick. And we got the agreement in 2007 because we put this set of, this package together. It included using our authority under the Fly America Act to allow European access to U.S. government-financed transportation in a way that did not affect the incentives for the CRAFT program. We worked very closely with the Department of Defense on that. It included an annex on franchising that you know better. You probably memorized every word of it, but that gave the Europeans some assurances that, or some meaningful assurance that under existing law, as interpreted by DOT, franchising arrangements are allowed. They can't constitute foreign control, but there's a lot you can do. And Virgin America stands precisely for that proposition.
And if I haven't thanked you or sucked up to you enough on that, I regret that, and I do so now.
Okay. If I weren't a government
That's
employee,
still-
I'd say check in the mail, but I can't say that.
All right, Sam. This will be shown after you're no longer a government official. You're speaking in your personal capacity.
That's right, I am.
Do you believe in the total elimination of all foreign ownership restrictions in the United States for airlines?
I would say I don't believe in simply wiping the statute clean of all those restrictions. What I do think we should look at and have a very serious conversation about, and which we haven't had. We've had position taking, hyperbole, different sides fighting it out. We must have total rights to ownership and control of U.S. carriers. Get rid of this, it's antiquarian, it's out of place. Over my dead body should this happen, it's not time, the national defense will be endangered. That's not really a conversation. We need to have that conversation in a calm way. And it's not a discussion about what we need to give to foreigners. It should be a discussion of what's good for the United States. And not only for our airlines, but also for our workers. And I think that conversation could yield results that having a rule that says under no circumstances whatever may a foreigner own and control any U.S. carrier, or even come close to it, frankly, and no potential for exceptions, waivers. That's a very strange rule. That presumes a knowledge about the world that is so absolute and tight that it's like making that one of the 10 commandments, an 11th commandment. My 31 years in government have told me to be very careful about those sorts of prescriptions. Murder is bad, but foreign ownership isn't necessarily always a bad thing. And we're seeing it happen around the world.
But do you think consumers really care about the ownership of an airline when they go to the airport?
No.
They want a low fare, they want their bags not lost, they don't want baggage fees.
They want quality.
They really don't care about the flag on the tail.
I think the vast bulk of consumers want the best possible service at the best price, and whether it's Air France, Etihad, Singapore, or United American, U.S. Airways, Continental.
But why isn't this an extension of your logic then? If Credit Suisse can buy First Boston, if Ford can buy Jaguar, that the most global of industries can't be global, why are you not in favor of complete elimination now?
Well, I think that we have to realize that several things. One, aircraft in our domestic airline, in our domestic aviation system, were the weapons of choice of the 9/11 terrorists. We want to make sure that, and need to have the sorts of protections. Maybe the CFIUS mechanism is adequate for this.
Explain CFIUS just briefly.
Well, it's the Committee on Foreign Investment in the United States. There's legislation that allows foreign takeovers of U.S. companies to be examined by an interagency committee of the U.S. government on a confidential basis. And there's the potential for transactions, takeovers of U.S. companies or the sale of U.S. companies to foreign companies to be prohibited if it would endanger the national security interests of the United States. We'd certainly want that in place for something like airlines.
You were quoted in the now infamous Dubai Ports World situation. You called that controversy a typhoon of xenophobia that pummeled the United States. Interesting words from a State Department diplomat. What impact did that typhoon have on your negotiations with the European Union?
It had a tremendous effect on the prospects, what little prospects maybe by that time, or the limited prospects of success in the rulemaking process for the NPRM.
Right. It happened right in the middle of the NPRM.
Right at the same.
Couldn't have been worse.
The timing was awful. So instead of having a civilized conversation about, is this NPRM, is this endangering our national security? Does it affect us in a bad way? Is this a reasonable thing to do or not? We had a lot of rhetoric that how dare we consider giving away the national jewels, our airlines, to foreigners. Of course, Dubai Ports was a case of taking a British-owned company that wanted to sell to a Dubai company some operations at various ports around the United States, and a huge furor arose over that. That was xenophobic in many ways. The rhetoric was xenophobic. And it was not a happy time. The opportunity to have a civilized, thoughtful conversation among smart people who cared, like Secretary Mineta, like Chairman Oberstar, like Jeff Shane, that just dissipated with the Dubai Ports event. And with Dubai Ports, it was very soon evident that the NPRM wasn't going to work. It took us months then for the NPRM to be pulled back, but it was a big blow to the negotiations. It delayed our ability to get to an agreement by a year or two.
Do you fault organized labor for their opposition to this in the sense that the premise of their argument that this would somehow lead to the exporting of U.S. jobs to foreign carriers that are non-unionized is a faulty premise?
No, not at all.
Okay.
And I wanted to come back. There are a couple other things than just the national security, the CRAFT program. One of the principal issues we have to deal with if we're going to address and have a civilized, open discussion about foreign ownership and control are the concerns of labor. And they are not illegitimate. The basic labor argument is if you allow U.S. and foreign carriers to merge into a single company, in the absence of a single labor law, there is no single U.S.-European labor law, no European Railway Labor Act. You then have two groups of pilots, two groups of flight attendants working for the same company under different laws where the way the law works to allow collective bargaining, enforcement of contracts is not clear at all. In those circumstances, whether it's an American controlling, let's say Delta, Richard Anderson being the CEO of Delta Air France, or the Air France management being the ultimate decision makers in Air France Delta. Either way, labor says that strengthens the relative hand of management in the labor management relationship, and we need to address the legal issue there. It's a tough, complicated issue. The Europeans sponsored two labor fora,
right.
One in Washington,
and we'll get to
one
it,
in
but your
Brussels.
second stage included a provision to take more fully into account labor
It's a
views.
significant issue, and I think my own personal view, just being practical about it, is that if we do, at some point in the United States, move to loosen, to liberalize our laws on foreign ownership and control, it will have to have some form of labor component built in, an evaluation of this.
But why? I mean, no one's suggesting that the agreement would be with the European Union, right? So that the European Union is highly organized labor favoritive. Right? You know, it's set up to help organized labor to a greater extent than organized labor in the United States. It's more unionized in Europe than it is in the United States, is it not?
27 different labor laws in the European Union. Labor, the social dimension, is one of the areas that is excluded from community European Union competence. And there are great concerns. The first labor forum, the most interesting comments and the most vociferous were from the European labor representatives who went on a broadside attack against Ryanair, which they see as exploiting these differences in European labor law, working around the edges. I don't judge that, but the feelings, the views were very strongly held on the European side. And I think American labor is not about to buy into that system where their European compatriots at places like British Airways, Lufthansa, Air France, they're not going to buy into that. We're going to have to find, if we're going to move forward at all, some way to address those concerns.
So why not just agree to a right of establishment in the United States so that a foreign airline can establish an airline in the United States and be subject to all United States labor laws? So the Railway Labor Act applies.
Right.
What's wrong with that?
I think that is a much less contentious proposal and one that ought to be more easily dealt with. The labor argument against it is if British Airways could establish I guess a greenfield sort of airline in the United States, that airline with the American employees, the American pilots, subject to all American law, would be a feeder. It would compete against the airlines where U.S. pilots and flight crews, flight attendants are working today, and they don't like that. And they think that that would be unfair, and there's opposition to it. So it's not an easily remedied solution. In any event, I think the chances that British Airways or Lufthansa or Air France would wish to establish a brand new subsidiary in the United States are very low. Our market's so mature, the low-cost sector is so well developed and vibrant that I think that's focusing the discussion on right of establishment would waste a lot of time and actually carry us off the focus that ought to be, which is, do we need global airlines? And do we want American carriers to be able to purchase airlines abroad, to merge abroad or not? And that's the bigger issue.
Do you think any U.S. carriers would want to establish in Europe and do the intra-Europe traffic?
On a passenger basis, no, not at all. No one's ever come to me and said that's what they'd want to do. On a cargo base, the all-cargo carriers, people like Polar, like Federal Express, UPS, there's some potential for that as they create global logistics and cargo transport industries. But it's not been something they've pressed us extremely hard to do.
I forgot to ask you about Fred Smith.
So one of the icons of all American industry in the modern era, maybe all took an idea, the famous paper at Yale, turned it into a company that is extraordinary. He's been incredibly supportive of our efforts. Again, a person who's bigger than life, funny, personable. I was in his office 6-7 years ago in Memphis, had a chance to view it. Again, just a humane individual who's built a powerhouse of a company that America can be proud of.
And his role in liberalization?
Very supportive. Supportive by, he's tough. And to be the CEO and founder of an enterprise like FedEx, you got to be that way. But he pressed us to, he was unrelenting in his criticism of the British and Bermuda too. He wanted to be able to operate rationally through the United Kingdom. He wasn't allowed to do that. He pushed us to get that deal, and in the end, we got it in 2007.
Would you ever hear from these CEOs directly?
Actually, my job, CEOs aren't usually picking up the phone and calling me. They might be calling Secretary Clinton or Secretary Powell or someone else or the Secretary of Transportation. If their voices want to be heard, they want them heard at the top levels. Right. But at the same time, there's always been an openness with all the executives, be it Glenn Tilton, be it Richard Anderson, be it Fred Smith, the three you've mentioned.
Foreign ownership and national security.
Yeah.
Did the Pentagon lobby you heavily not to give away the store on foreign ownership because of national security concerns?
Well, we have collective decision-making in the United States executive branch. So what I did before we were pressing to change anything was we brought together a delegation for the U.S.-EU negotiations that included the Pentagon, Department of Defense, the people who deal with Scott Air Force Base and the Airlift Command. They were an integral part of every round of negotiations where ownership and control was on the table, where we were talking about the Fly America program, in which they have a strong interest. And what we did was to build a consensus. DOD signed off with the Department of Transportation
on the
rulemaking.
They didn't oppose, Transcom did not oppose that element of change in the rulemaking?
There were lots of discussions between DOT and DOD about how it would work. They worked out, I believe, a memorandum of understanding on how they would implement the rulemaking, and DOD signed off. DOD also signed off earlier on going from 25 to 49%, something not worth pursuing in my own view. It was an idea, a good idea, but several years too late.
It had been proposed many times, actually.
Proposed many times.
By Democrats, by Republicans. Never went anywhere.
It's not where we should not waste our time on going to 49%, in my own view.
Do you believe foreign ownership is a legitimate national security issue?
I think you have to work out how the CRAF program would work with foreign-owned airlines, and I think that would require legislative change. The more amorphous and difficult issue is, even if you could work that out, so if Air France owned Delta, Delta has obligations, voluntary obligations, but they've signed up to the CRAF program, and in the event of a war that Air France or the French government, whatever, didn't want to support, they stopped committing doing that. We'd have to have legislation that says, well, you lose your rights to fly.
Did they bring up that particular issue, that the government of France objected to military overflights in support of Desert Storm?
That was not a specific issue. The more amorphous issue is, even if you could deal with the technical responsibility to keep people to their CRAF commitments, I think there's a level of, I call it psychological trust, between military planners responsible for the nation's defense and American-owned companies. It's just a sense that patriotism is important to the military, it's important to me, I think it's important to you, and American patriotism is something you find in Americans. And so they're comfortable with American-owned companies. When it's a foreign-owned company and you really depend on them to get the troops and materiel to the theater of war, and you've got to do it, you have no choice, you're going to be less comfortable. And so dealing with that comfort level at DoD would be one of the big challenges.
But we have a constitution and it says there's a commander-in-chief.
Right.
Do you have any doubt but that the commander-in-chief in a time of war could call up and force the cooperation of civilian aircraft to move troops?
Whether owned by foreigners, Americans, or anybody in between, no, I don't at all.
Or force them to enter into a contract that they will support in the time of national emergency or war?
Ken, I agree with you. And if we had that sort of war, I don't think there'd be any doubt but that we'd have the legislation to allow that. But when we're talking about a legislative change to alter the existing limits on foreign ownership and control, we'd need to have a legislative packet that put together exactly how that would be handled and do it in advance.
So I get it straight.
Yep.
You do believe organized labor has legitimacy in their arguments. You do believe the Pentagon has legitimacy in their arguments for national security in terms of changing foreign ownership. Is that right?
Right. Their arguments cannot be dismissed as poppycock, as unfair, as irrational. That's not to say, however, that there aren't answers to those arguments. Counter-arguments, or rather than casting it as an argument, answers to the problems that they raise, and if we'd have that conversation, work on it really hard, maybe we could find something.
Yeah,
how
do we get out of this this GATT form of discussion, the general agreement to talk and talk?
Yeah.
How can we actually resolve these issues so we can begin to see global consolidation and acquisition instead of joint ventures and loose alliances, albeit with antitrust immunity?
So one of the best things we've done in the second stage agreement with Europe is to agree we're not having a formal third stage of negotiations. The place to deal with ownership and control, I've now come, School of Knox, to realize is not in a negotiation with a foreign country. It sets up the equation in the wrong way. They're asking to own us and we're trying to deal with it. Again, it needs to be something we need to do to position our aviation, our airline industry for success in a global industry in the future. So it needs to be a conversation among Americans. It needs to have proponents in the United States. I think our airlines should be leading the pack, saying to the administration, Democrat or Republican, we're seeing consolidation everywhere in the world. We're seeing, look at Lufthansa. It's incorporated into itself, into its family, 5 or 6 significant partners. Iberia and BA have come together. There's talk about consolidation, China Eastern, China Southern, more consolidation around the world. Are we going to be a part of that, or do we exclude ourselves from it by having our rules?
Or
if
is
they
it
bring that conversation, then we engage with labor, we engage with Congress, and we'll see where it comes out. But
I think one of our prior conversations here at the Institute was with my friend and yours, Dorothy Robine,
Yep.
with, I believe, Michael Levine. And she always said something like a disaster is a terrible thing to waste.
right.
Is what we really need, not all this conversation and labor getting together with airlines. We need a liquidation of a major carrier with tens of thousands of jobs at stake, and a foreign government who is friendly to the United States, saying, we will come in and preserve these jobs, preserve the service, preserve the competition. Is that what's needed? Are we just simply lacking an emergency, and should we come up with one?
Well,
I didn't mean the last part of it.
I'm not looking to come up with emergencies. I could see a transaction-driven change in the law as a possibility.
Like when TWA was going under, wasn't there some talk that someone with Taiwanese interest was going to save St. Louis, save TWA?
I think the question would be, how likely is that scenario? If American investors, American capital aren't willing to come in, is it a dumb foreign investor who would come in and want to save the U.S. company? Maybe, maybe not. It could be, Ken, the key that would open that discussion and the progress towards a change in legislation. At the same time, you got to realize, and you know this better than I, as nice as all the people in all the airlines are, as friendly as they all are when we're in negotiating teams, these airlines compete against each other with vigor, with vehemence, and that is a great thing. It's the American capitalist system. It's great for consumers. So if you had one airline, Airline X, going under, and it was going to be bailed out by some foreign company, and all we need is legislative change, I'm not at all sure that other U.S. competitors would see it as in their interest at that time and in those circumstances to come to the rescue of their U.S. competitor and say, let's change the law. Maybe they would take the lofty view, but I don't think we can count on that.
Shouldn't as you say, dumb foreign investors have the same right as dumb U.S. investors to invest in the U.S. airline industry?
I'm a big believer in foreign direct investment in the United States. It creates enormous, millions of jobs here around the country, jobs that on average pay better in all sorts of sectors. So in general, I think we want to encourage the opportunities for foreign investors to come into the United States, to bolster our economy, and by the same token, we want to protect the rights of U.S. investors.
But aren't you worried that the airline industry has never earned sufficient return for its investors? The long-term financial health of the airline industry, and frankly, like every other transportation industry, whether it's rail, shipping, Amtrak, never returns equity, and what's desperately needed is consolidation in economies of scale and scope, and that government needs to get the hell out of the business of restricting investment.
It would seem to me that we're seeing elements of consolidation even in the last few days. American Airlines is on the outside, but we've seen Delta and Northwest, United and Continental, their deal now approved.
Southwest and AirTran?
Southwest
maybe?
and AirTran. We'll see what the result is there. We're seeing that. We've also seen remarkable constraint by airlines in reintroducing capacity too soon. Airlines are showing some profitability, but yes, your point is a good one. Airlines have not earned the cost of capital for many, many, many years and over an extended period of time taken together. And that should be a matter of concern. I don't know that the inflow of foreign capital by itself, portfolio investment, makes much of a difference there. That's capital that could be lost.
But the reciprocal benefit of being able to acquire one of the 1,200 plus airlines that we have, I think IATA's down to about 232 airlines, but I mean, clearly the financial health of the automobile industry is somewhat restored, but we have a handful or two handfuls of automobile manufacturers. There's very few other industries that have this notion that every government should have its own airline. It's serving all of its points.
Horrible idea.
They're political points. They're not
Horrible
economic
idea
points.
introduces economically unjustifiable capacity and cost into the system. And in Europe, one of the good things with the European Union is that the opportunity now exists for airlines that in a modern global system really don't justify their existence. A tiny airline with a tiny country can now associate itself, be bought by a larger carrier, form an alliance together, and do the sort of capacity planning that's rational economically as opposed to built on national pride. We've got to have 5 flights a day between our capital, our small capital, and all these other points. That makes no sense. So in a way, Europe's opening up to consolidation through the creation of a single aviation market is a remarkably wise economic step by Europe.
Is Europe more forward-thinking and open on liberalization than the United States, the home of free markets?
I think my personal view is no, if you look at practice. Now, sometimes the rhetoric, the positions that were outlined vis-a-vis the United States, the European vision was broader than the United States vision. Our open skies concept was a subset of the European vision of economic harmonization, sort of a single transatlantic open sky. In practice,
This
however,
was the European Airlines.
Yeah, back
position.
in 1999, I think the transatlantic common aviation.
What was your reaction to that? This is Ulrich Schulte-Strathaus.
The whole team at TC,
Right.
I think actually before Ulrich came in. But our reaction at the time was the way that paper was drafted. Some of the ideas were worth considering, but it had a very heavy bureaucratic regulatory overlay. And in part that was driven by European carriers wanting common regulation, common schemes. Not a bad thing, but we didn't want to recreate the Civil Aeronautics Board as the price of having open skies. Our view, our focus was always on let's open up the markets, let's open up the frequencies, let's allow free pricing. If you get those basics there, you can work on harmonization where it makes sense, but don't make it beholden to some sort of regulatory harmonization with a transatlantic, maybe based in Bermuda, CAB.
But they have long advocated for eliminating cabotage restrictions.
Correct.
Tell folks what those are and why have you defended them for so long?
Well, the cabotage discussion is one of the great red herrings of aviation in the modern era, but it always gets raised, and I love to talk about it, so I will for a brief period.
Okay.
So the Chicago Convention recognizes in one of its early articles this thing called cabotage, a term taken from maritime practice, which is the carrying by a foreign shipper, airline, of people or cargo between one point in your country to another point in your country. So cabotage would occur if Lufthansa flew from Frankfurt to New York, picked up passengers in New York, and carried them on to Los Angeles.
What's wrong with that?
It's been prohibited by our statute. I'll come to that. Whether it's wrong or not, it's irrelevant. It's prohibited by statutes in the United States. It is prohibited by statutes in many, I think a majority of countries around the world, but I haven't been keeping tab. The problem with changing the law is cabotage is the third rail of U.S. aviation policy. Rightly or wrongly, changing cabotage laws would be, we would have to pay a huge price to try. The likelihood of succeeding with Congress against strong opposition from labor unions, probably some U.S. carriers, would be enormous. And what would be the benefit? How likely, how often do U.S. carriers, passenger carriers, pick up passengers at one point in Europe and carry them to someplace else in Europe?
All right. Have you flown Emirates?
Yes.
Good service. Nice airplanes. Financially successful. I would like to fly them from New York to LA. Very comfortable.
I'm not sure they do
Nice
that.
flight attendants.
I'm not, no comment there especially.
Just said nice.
Okay,
Personable,
fine.
I meant. Personable.
I saw the gleam in your eye, Ken.
What's wrong with that?
In an abstract way, nothing's wrong with it. How important would that be in adding the sort of major service improvements in the United States that we're crying out for or not crying out for? I don't think so. And the fact is that U.S. carriers for years have not transported passengers between one point in Europe to another point. They've used alliances. When Lufthansa flies to the United States, they hand off their passengers to United. When United flies to Frankfurt or Munich, they hand off passengers who continue on the Lufthansa system to other locations. It's an efficient mode of transport. It makes a lot of sense. Not since the days of pretty much Pan Am and TWA have we seen this intra-service, intra-European service. I think that's a relic of the past, sort of cabotage services or intra-European services. Legally, there's a real difference. Whether it's economically relevant or not, legally there's a big difference between flying from New York to Los Angeles and flying from Frankfurt to Rome. The correct analogy is flying from Frankfurt to Munich or Hamburg to Stuttgart, and we never sought those cabotage rights.
But your defense of cabotage says that if I'm going from Dubai on Emirates to New York, to Los Angeles with a stop in New York, that they cannot take on passengers and continue on to LA.
Yeah, I think the so-called fill-up cabotage,
Right.
eighth freedom as opposed to ninth freedom cabotage, is something you could have a conversation about, but the price you would pay for having that conversation and seeking legislative change would deflect your attention from other things like ownership and control, which should be the focus of attention. I also think that there are many in the United States who would say if you're flying in our huge domestic market, we're not a small country like Germany, a small country like Italy comparatively. We have a huge economic aviation sector, that we'd really like the flights that are domestic to be under the oversight of the Federal Aviation Administration and the Transportation Security Administration, alpha to omega, the whole thing, not just
Okay.
a little bit of complying with international standards. Labor feels the same way, that if you're flying in our home market, U.S.
Right.
labor law ought to apply, not German law or Kuwaiti law or Emirates
All right,
law.
we'll get back to that in a minute and more conversations with John Byerly from the State Department. Thank you.
Thanks.